Hello, everybody. Hello, hello. Welcome, welcome. This is a last minute, good afternoon, last minute live here. Hello, hello. I am just not able to get my voice back. I have just a little bit left. So, hello, Kristen. Good to see you. I wanted to spend what voice I had left here talking about the update that we've got out of Georgia, everyone. We had an order that came down from Judge McAfee just this morning. Now, again, I just do not have much voice left, so I will probably not be able to go live tonight, unfortunately. I just don't, I cannot seem to shake this cold I've got. So I thought, let's just go ahead and do this while I still have some voice left. Yes, I've got tea. Oh my goodness. Hello, hello. Yes. No, I'm okay. I just can't seem to quite shake this. So I did want to kind of talk about this, though. We have an order today on the defendant's special demurs out of the Georgia case. So we haven't really heard much out of Georgia recently. We are supposed to be getting an update coming on pretty soon regarding Dee Willis's status, but this is an update on the actual case itself, everyone. So let's just take a few minutes here and let me explain kind of what's going on here. Yes, some of the charges being dropped. So if everyone will remember or take a walk with me back in time, it seems like so long ago. We originally had all of our defendants here listed. We had 19 defendants. And then out of those 19 defendants, we had a total of 41 charges that were done. So 41 charges, and the RICO case had to do with bad acts. So we had multiple counts, but we had over 161 acts. So those acts were not charges, they were just acts to support the RICO charge. So the RICO is the conspiracy issue. So we kind of had that in this at this point for this case. So what has happened is there have been, let's count them out here, 1, 2, 3, 4, 5, 6 people who have said we've got issues with the indictment, and so we would like you to drop the indictment. So Judge McAfee has reviewed and has agreed to dismiss these counts. Now, again, keep in mind, everyone, we've got 41 counts. We started with 19 defendants. So I'm not surprised that this has happened. And no, I don't think it'll have a significant effect on the case at all, in my humble opinion as a former prosecutor. So let's take a look, though, at what Judge McAfee felt there were some issues with. So the first count, again, and we are only talking about these 6 defendants. So we have count 2. So let's take a look here at count 2. Solicitation of violation of oath by public officer. So we had, when this was set out, they're saying that they were requesting a particular officer, let's see if they listed it out here, to disregard their oath of office. So let me just take a peek here. You can go to the acts regarding the RICO are in the front, but the counts themselves are in the back of the indictment. So let's take a look. All right, so number 2 is our first one. And number 2, we have Giuliani, Eastman, Ellis, and Smith. Now, Ellis has already pled guilty for individually and as persons concerned in the commission of a crime on the 3rd day of December, unlawfully solicited, requested, importuned certain public officers serving as elected members of the Georgia Senate and present at the Senate Judiciary Subcommittee, including unindicted co-conspirator individual aid. And then we're going to skip down here. Unlawfully appointing presidential electors from the state of Georgia in a willful intentional violation of the terms of their oath. So this is what that count is supposed to be about. I'll stay with you as long as I've got voice left, everyone. But I came on early because I'm not going to have much left. So that's the first count that the judge wasn't sure about. Now, what Judge McAfee made sure to say was, hey, there's been a lot that was pled out in this indictment, and that's great. But I've got to make sure, it's part of my job, that everything is pled out clearly so that defendants can come up with a defense. So for these counts, he felt that they were just too vague at this point. Thank you, Kristen. So that was count 2. The next one is count 5. So solicitation of violation of oath by public officer. So that's the next one. Let me just read through the solicitation of violation of oath by public officer for count 6. And then count 23, we have, again, solicitation of violation of oath by public officer. And then count 28 is, oops, I flipped this page here. Count 28, another solicitation. This was the phone call to the Secretary of State in Georgia. So solicitation of violation of oath for a public officer, and how this was written. This is another one of the counts that was dropped. And then number 38, which is solicitation of violation of oath. So it looks like there were some problems, according to Judge McAfee, with how the solicitation charges were drafted and put into the indictment. So we have only the solicitation, none of the other acts. So the false statements, the RICO, impersonating public officers, forgery, conspiracy, influencing witnesses, attempt to commit, filing false documents, another criminal attempt, false statements, false documents, conspiracy, all the conspiracy pieces, all of those are still in place, everybody, but the solicitation charges have been bumped. Can it be appealed? Not at this point, no. This isn't really something that would be appealable because we've got a judge deciding whether or not there is enough to go forward on an indictment because it's so early in the case. The best way to deal with a situation like this, everyone, would be for the prosecutor, once these are bumped out, for the prosecutor to try to rework these charges. So that's really what the issue is. So again, it's only with the solicitation of violation of oath, and it has to do with how they were pled out in the indictment. So just keep that in mind as we're going through this. Violation of oath here. Yeah, she can refile. Exactly. And that's all you have to do. It looks like, again, it has to do with the format in which that they were pled. And, he's just saying there wasn't enough information in order for the defendants to build a case. So that's all there is. And that means those need to be pushed out. But once you come back, you can rework those. But let's go through exactly what he said here. Hey, Lucky Sticks, why don't you chill out? You can feel free to move along. That's all right. So count number 2 alleges that multiple defendants solicited elected members of the Georgia Senate to violate their oaths of office on December 3rd of 2020 by requesting or importuning them to unlawfully appoint presidential electors. And that's the first one here. And then we have count 5 alleges defendant Trump solicited the Speaker of the Georgia House of Representatives to violate his oath of office on December 7th by requesting or importuning him to call a special session to unlawfully appoint presidential electors. And again, we only have a couple of counts that were tossed. Count 6 alleges defendants Smith and Giuliani solicited members of the Georgia House of Representatives to violate their oaths of office on December 10th by requesting and unlawfully appointing presidential electors here. Count 23 alleges that multiple defendants solicited elected members of the Georgia Senate to violate their oaths of office on December 30th by requesting them to unlawfully appoint presidential electors. So all of these have to do with appointing those presidential electors. Now, count 28 Count 28 here alleges that defendants Trump and Meadows solicited the Georgia Secretary of State to violate his oath of office on January 2nd by requesting him to unlawfully influence the certified election results. So this is the Georgia phone call, everyone. That's count 28. And then count 38 alleges that Trump solicited the Georgia Secretary of State to violate his oath of office on September 17th by requesting him to unlawfully decertify the election. So these two counts are the ones involving the Secretary of State. So Judge McAfee then goes into what the defendant's argument was here. And then let's just kind of fast forward to why he has held the way that he has held here. All right, so the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged an abundance. However, the lack of detail concerning an essential legal element is, in the undersigned's opinion, fatal. As written, these 6 counts contained all of the essential elements of crimes, but fail to allege sufficient detail regarding the nature of their commission, i.e. the underlying felony solicited, and he's citing the Georgia case law here. They do not give the defendants enough information to prepare their defenses intelligently, as the defendants could have violated the Constitution, and thus the statute in dozens, if not hundreds, of distinct ways. Under the standard articulated by our appellate courts, a special demurrer must be granted on counts 2, 5, 6, 23, 28, and 38, so to be quashed. Now, this, again, everyone, it seems like it may feel overwhelming, but this is actually relatively typical. If we had a motion for a bill of particulars, or if there had been problems with the indictment, then this is what would happen. The judge would come in, make a ruling on it, and then those counts get tossed. The prosecutors then need to figure out how to properly plead them again and bring them back in, if they even want to go forward at all. They could choose to come back at a later date and file those charges at another time. They don't have to have them filed in here. So DA Willis chose to kind of throw everything that she had here into the indictment, which was absolutely fine. But it didn't mean that she had to in order for the case to go forward. So this is something that can tend to happen here. So, pretty normal. Now, a sub footnote here, let's hit number 8. This does not mean the entire indictment is dismissed. The state may also seek to re-indictment, supplementing these 6 counts, barring future prosecution after a second quashal. Even if the statute of limitations has expired, the state receives a 6-month extension from the date of this order to resubmit the case to a grand jury. So we even have a 6-month extension of the statute of limitations. Nor is it inevitable, presuming the state presents the appropriate motion, that the identity of future grand jurors will be publicly accessible. And then he's citing different motions here. So that's the first part of the footnote. This is an area of the law where federal courts have achieved greater efficiency, and one might wish that future grand jurors could be spared this inconvenience for something so easily remedied. And he's citing the federal rule of criminal procedure here. But Georgia law currently provides no such option. So it just has to do with an inefficiency of how the Georgia law is at the moment. And then actually he is talking about a bill of particulars right here. So a bill of particulars is not a recognized pleading in Georgia. So, like, for example, in my state, everyone, if someone had had a problem with how a prosecutor had pled out and had a problem with those 6 counts, we would have pled a motion for a bill of particulars. That would have been presented to the judge, and the judge would have granted that. And if they had granted the bill of particulars, it just means that the prosecutor has to go back, rework the words, and refile it under the bill of particulars. But they don't have that option in Georgia. So because they don't have that option in Georgia, all he can do is quash these 6 counts. All right, is everybody following me on that? Whose counts got dismissed? So we have 6 we have 6 defendants, and we have the solicitation to violate their oath are the counts that were dismissed. All right, so just those solicitation counts, and it's because of how they were worded in the indictment. So next, alternatively, the state may request a certificate of immediate review pursuant to 572, which the court would likely grant due to the lack of precedential authority. So they're setting out new precedent on their criminal procedure rules here. Absolutely, Lisa, no problem. Defendants Chile goes further and claims count 23 also fails because there's no nexus between the offense and the public officer's official duties. Here, the court disagrees and finds that the Georgia Senate can play a role in election contests and that the appointment of presidential electors relates to their official duties. So that other question that was raised was denied. All right, so let me walk you through one more time from the top, everybody. So let's take it from the top. Taking it from the top. So we have Trump, Giuliani, Eastman, Meadows, Smith, and Chile. And those are the defendants who were involved in the solicitation charges. Solicitation of violation of oath, solicitation of violation of oath, and here we have another solicitation of violation of oath here and here. So the Georgia phone call was asking the Secretary of State to violate his oath, as well as the second phone call asking him to violate his oath. What Judge McAfee is saying is you were not specific enough in how you pled out that they were asking him to violate his oath. Well, how so? That needed to be more specific. It wasn't pled clearly enough. So those 6 counts are going to be removed. Now, because they don't have a bill of particulars, which is a mechanism that we use in a lot of states to kind of clean up an indictment if we make mistakes, then they had to quash it. So he quashed it and he said you can refile it. You just need to rework it. So, and again, as we take it from the top, everybody, lest we forget, we have 19 defendants and 41 counts and 161 bad acts of racketeering. So we are only talking about 6 counts regarding the solicitation to violate an oath, and that's because the prosecutor didn't clarify well enough in their description of what they violated their oath doing. So this by no means is a dismissal. There's no walking. No, nobody's walking on anything, everyone. Let's be clear again on what's happening here. No, this is a huge indictment, and it was pled huge. Many would say she overpled it, and maybe she feels that way, maybe she doesn't. But in other words, those 6 counts need to be reworded and refiled if they want to go forward. But let's go through the counts that are in place, all right? So the RICO charge is in full effect. Everyone still is charged with the RICO, all right? Everyone is still, or these people, charged with false statements in writings. Count 3, count 4. Count 7 is false statements in writings. Count 8, impersonating a public officer. That's still charged. Conspiracy to commit impersonating a public officer, also charged. Forgery in the first degree. Conspiracy to commit forgery in the first degree. False statements in writings again, conspiracy to commit those false statements, criminal attempt to commit filing false documents, conspiracy to commit filing false documents, forgery in the first degree, conspiracy to commit forgery, false statements in writings, conspiracy to commit false statements, criminal attempt to commit influencing of witnesses, criminal attempt to commit influencing witnesses again. Next, we have criminal attempt to commit false statements in writing, false statements in writings, count 24 and 25. Count 26, false statements in writings, filing false documents, count 27, false statements in writings, conspiracy to commit solicitation of false statements. So this solicitation was written out properly, so that one stays in. The next one, influencing witnesses. Conspiracy to commit election fraud is still fully charged on the table. Second, conspiracy to commit election fraud, also on the table. Conspiracy to commit computer theft. two charges, computer trespass here, computer invasion of privacy, still charged, conspiracy to defraud the state, false statements and writings, count 39 and 40, and perjury, count 41. So all of those counts are still going forward. Okay. All of those are still going forward. And not only that, but the judge was clear that all of the acts, also for whomever is interested, we have all the counts listed as well. All of the racketeering, the RICO acts, are all still in play with a couple of exceptions when it comes to just that solicitation element. All right. So we have all of these acts of racketeering still in place. All of those other counts still in place. So again, we've got a prosecutor here without having enough clarification on exactly what they meant by solicitation, violating their oath. That wasn't clear enough, and so they were dismissed, basically because they do not have a mechanism called a bill of particulars in Georgia, because they don't have that in place, and I'm not sure why they don't. Maybe they will now, but because of that, he had to quash the counts. Yes. All right. So, do we have any other questions? Can I help with any other questions? But this is not the end, everybody. This is just clarification. And quite frankly, I think any of us, if we felt that there was something wrong with the indictment and a judge agreed, then this is the proper protocol. This is what it should do. How do you think it'll affect the decision on Fani? It shouldn't have any effect. It shouldn't have any effect. She pled a huge indictment. This is a huge indictment, everybody. You've got 19 defendants and 41 counts. It's huge, no matter how you slice it. RICO cases are huge. For a couple of these counts to have not been pled, with enough detail, was bound to happen. Will they refile? I'm not sure. I would think so. But it might be smart for them to refile as a brand new case instead of attaching it back to this case file. But that would be my personal strategy, because I would want to pull these guys out. I mean, you want to split these up as much as possible because we have so many defendants. That would be my strategy. But for their strategy, they might want to just put all the evidence on at once. Although the evidence for the solicitation of the violation of oaths is its own packet. So it's its own trial in and of itself. So each one of these is going to be a mini trial. So basically what they've done is they've said you've got 41 mini trials. 6 of them weren't pled specifically enough. So those 6 need to be reworked if you want to bring them back in. Yeah. John. Well, you said it, not me. Yeah, I mean, she can submit again. The other thing, too, is Judge McAfee said, by the way, I'm adding an extra 6 months onto your statute of limitations. So you even have an extra 6 months to even think about it. So to take the time, think about these 6 charges, think about the problems and things that have happened since you filed, and figure out if you want to refile these in a different way. How do you want to go forward with these charges on the case? We are not going to have a double jeopardy issue. We're not going to have a statute of limitations issue so long as you file, and I'll give you extra time. Yep, so I really don't see too huge of a problem. Are any defendants not getting charged because of this? No. So you probably can't tell because of my ridiculous notations here. But what I did after each count was I listed the person who was charged. So for count number 2, we have Giuliani was charged, Eastman was charged, Ellis was charged, and Smith. So for each one of these, and he knocked count 2 out, count 5, which only applied to Trump, count 6, which applied to Giuliani and Smith, and a few others. So none of these knocked anybody off the list. They're still, all of these other charges are still in play. There was not a single person that was only charged with 1 count for solicitation of violation of oath. They were charged with multiple counts. And in fact, I think only Mr. Trump was the person that was only filed on charge 5. So I think that's about it. Let me just double check. We have 3 people charged for 23. We have 2 people charged with 28 and 2, just Trump, looks like just Trump on 38 too, when he called specifically and asked him to toss aside the results. See it on your paper. We're in. Yes, I know. This is going to be quite the case, everybody. And even from the first day it was filed, this was really, this was a huge indictment, everyone. So the fact that we've made it this far after like 19 different motions to quash and demurs, I think is pretty amazing. And again, so all of these other counts, all of these other things are still going forward. It just has to do with those solicitation. The wording of the violations of their oath was not specific enough. Be a landmark case. I agree. The phone call's not evidence. No, the phone call is evidence. The problem is charging a violation of an oath for that phone call is not allowed with how they wrote it. They didn't write it specifically. They didn't say exactly how that phone call violated his oath. And so because they weren't specific enough, it's tossed. That's it. The phone call is evidence, of course. That stays in, and they can, of course, recharge as well. They just need to be more specific about how it violated the oath. Again, I know. Good afternoon. Yes, so just a little bit of an update out of the Georgia case, everyone. And it's really stressful if you don't understand how all of this is set out. It can be extremely stressful, but absolutely, Ryan, you're very welcome. Absolutely. So again, we have only these 6 solicitation charges. And not even all the solicitation, but only these 6 have been pushed out, have been quashed or set aside. It doesn't mean that they can't be brought. It means that they need to rework the language. The language wasn't specific enough, so they need to make the language more specific and refile if they want to go forward, or let it go if they just want to place all of their eggs in one basket, so to speak. Yes, the ruling was just this morning at 9:23 a.m. This is the filing right here. So this is the indictment, and then State of Georgia was filed right here. Very, very specific, everybody. Again, we have 6 counts, again, out of 41. Only the solicitation of a violation of oath counts, and it's only because the wording was not specific enough. Absolutely. No, the impersonating an officer, those are still on. Nope, the impersonating public officer counts 8, and the conspiracy 8 and 9 are still on. Nope, those were still held. And lots of these other counts were also requested to be removed, and he denied all of those as well. It was literally just with the solicitation to violate an oath because they were not specific enough about it. Best guess on timeline ruling. I'm not sure, Paul. I'm waiting. I'm going to wait to see what happens on Friday. I think that'll be really telling. By the end of this week, we should have a good idea of where things stand. Are these charges where plea deals were taken? Yes. So Jenna Ellis was involved in one of them, and she did take a plea agreement. Now, whether or not that particular one was pled down or what, I don't remember off the top of my head. But yes, it was. But again, they can refile all of these again. Thanks for clarification. Oh, you're welcome. You're welcome, everybody. I hope this helps a little bit. I think it becomes really frustrating when you're not sure exactly how the whole process works, for sure. So it can get really stressful. But no, we're in good shape. The case is still at the same place it was before. We've just 6 counts have been bumped because of, in my opinion, because of a clerical situation. The prosecutor didn't plead it out, and I don't know why they didn't plead it more clearly. Maybe they didn't think they had to, maybe they thought they had pled it clearly enough. But my other question would be, how many times have they actually charged someone with solicitation of a violation of oath by a public officer? Probably not very many times. And so this is kind of a case of first impression, and they just did not plead it out the way that they needed to have it pled. Yeah. Yep. We appreciate. Oh, you're welcome, Marley. I hope it's helpful. Not gonna. Yeah. I mean, I really have no idea what's gonna happen. That's not going, soulmates. That's not going to be decided right now. The judge, I think, is making that decision on Thursday. So tomorrow, I believe, is when that's going to be decided. That full situation. Love your notes. Well, I mean, I gotta keep all of this straight too. This was a beast of an indictment, everybody. Beast. So it takes a lot to kind of keep it all straight, for sure. Was presented was so different than the news. Well, yes, I know. That's why it's so frustrating, everybody. When I turn the news on, I'm like, no, stop. What are you saying? That's not right. So, no, we're okay, everyone. No, I don't think so. Yes. So, yep, no, we're good. This just, again, has to do with those 6 counts that were just pulled from the indictment because they weren't pled with enough specificity. So, because of how the procedural rules work in Georgia, the judge just quashed it. So, playing for shock value. Yeah, they really are. And, I get it. But, I'm not. I'm not here. No. No. Put your soul back. No. No, we're good. We are good, everybody. Yes, I will. I will go ahead. Thanks, Thomas. I will go ahead and sign off for now, everyone. I really do hope that I can come back on again for a little bit later on tonight and re-explain this again to everybody. But so pass it along. Excuse me, everybody. Pass it along. We're in good shape. I will make sure to come back on as soon as I can to make sure everybody understands what's going on. So thank you all for joining me. I will go ahead and sign off for now. Hopefully I'll be able to pop back on a little bit later on and give everyone a heads up again. So I will see you all later after lots of tea. So take